and note of gratitude to LJRF and the leader of LJRF, Sir, for having invited me to talk on this topic, which is of current importance. Now, our time is scanned. As our time is scanned, let me directly go to the area of discussion for the day. The area of discussion, as all of us know, is governor and Indian Constitution. And my presentation is going to be a combination of the slides which I've already put up, along with, of course, I'll be speaking along with. So my presentation is going to be that. I invite the attention of the speakers here and the audience here to the slides also. So over to the slide. I've got a picture of a man who cannot be properly understood, but who has got a lot of powers. So I symbolize, it's symbolic, and governor's position is also said to be symbolic. And this picture, to me, this picture symbolizes that symbolic position of governor. Governor of a state is a person difficult to understand, and going through the constitution would tell us or make us understand or make us feel that it is done deliberately. A person of Ambedkar's, Dr. B.R. Ambedkar's caliber has kept the role of governor, perhaps deliberately, uncertain. So why is it so? Is it uncertain? What is his position actually? And why is it kept so? What does the person is supposed to do? These are the things which I'm going to discuss. So this picture again to the mind. Please have that in mind. Governor is a person difficult to understand, but with a lot of power vested in him or her. Okay. So Constitution declares under Article 153 of the Constitution that there shall be a governor for each state. It's understood that this form of governance by appointment of a governor for each state by the center is an adoption of a Canadian model also. Of course, its predecessors can be found even in British India and even under Government of India Act 1935. Whatever it be, Article 153 of the Constitution just declares that there shall be a governor for each state. And it further says, the Constitution further says, the executive power of the state is vested with the governor of the state. And appointment of the governor, that is important for us to understand, as though we know it, it may be important for us to stress that in our own mind, that appointment of governor is done by the president, who is part of central government under Article 155. And it says that under his hand, under his signature, and under his seal by way of a warrant. That's all what the Constitution says. And his term of office is not mentioned, or it is said that it is at the pleasure of the president. So it is at the pleasure of the central government. So says Article 156 of the Constitution. Let's move on to understand him better, or rather try to understand the uncertainty of the person. So the qualification for appointment of the governor, the minimalist in the Constitution. He should be a citizen of India. That's the first requirement. And second one is he should not be less than 35 years of age. He should have completed at least 35 years of age. All these are known to us, but it's important for us to understand that it's difficult for us to understand him. And conditions of governor's office: he should not be holding an office of profit. He should not be an MP or MLA. Those are the conditions mentioned. Otherwise, any person who is felt to be fit to be a governor, no, and to be a governor by the president. To say in other words, by the center, can become a governor. And author from affirmation is to be taken or to be administered. It could be either in the name of God, or there is a flexibility to go for solemn affirmation. And it is administered by the Chief Justice of the High Court concerned, or the senior most judge under Article 159 of the Constitution. And it further says about the discharge of functions of the governor in certain contingencies. It says that the president may make certain arrangements to discharge the function of a governor if he is not available. And it does not say appointment or anything of that sort. It says president may make such other arrangement. Again, it's not very clear or certain. And going further, and governor has the power to grant pardons, etc., and to suspend, remit, or commute sentences in certain cases. And again, it is found to be exercised by the state governments. Sometimes governors have a say in this. It is under Article 161 of the Constitution. Then it further says that the executive power of this state no, is about uh, executive power of the state is vested with the governor, and the council of ministers are for the council of ministers is for the purpose of helping him out in discharging in the function. And executive power of the state would be as per Schedule 7 of the Constitution, wherein you may have to look at state list number 2 of the Constitution. So and that's a brief about the position of the governor under the Constitution. So here the relevant articles are Article 153 to Article 162 of the Constitution, and the role of governor is quite similar to that of the President of India. We could say that the role of the governor is quite similar to that of the President of India. Here, what we say is it's similar to that of the President of India. It may not be identical to that of the President of India. I would like to make a distinction between similar and identical. And going further with this thought, we can understand that the governor performs the same duties or similar duties as the president, and governor stands as executive head of the state, and working the governor's working remains similar as of the office of the President of India. So these are all okay, but what you may have to see is there is a but, a very blatant but, an important but here. Though his working style, his position, etc., are similar to that of president, he is not identical to the President of India. The governor has certain peculiarities which are distinctively different from that of President of India. No, how does he become so? And that's what we are no looking at. We may be spending our time on. So to look at this, governor has a dual power, unlike President of India. President of India has a singular power wherein he is to represent the central government. Of course, he is the head of the state, and he has to act as per the advices of the Council of Ministers. But here, notably and importantly for us, it is to be looked at. It is to be understood that there is dual role for the governor. So how is it to be understood? We have a picture just for the purpose of understanding, or just a contextual thing. Governor acts as the head of the state, and in that capacity, he acts as per the advice of Council of Ministers. And apart from this, apart from the role as the head of the state, he has a role as the agent or representative of the center, and he has got a power or discretion to ensure that the matters at the center, matters at the state are no 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 are happening as per the constitutional provisions. No constitutional provisions. Let's understand this. There's a dual role, as I said, the constitutional head of the state and the representative of the center. Going further, if you go to Article 163, we may have to dwell more time on this. Article 163 of the Constitution, which says about the Council of Ministers to aid and advise governor. And if you go to the clause one here, it says there shall be a council of ministers with the chief minister at at the head to aid and advise the governor in the exercise of his functions. That's fine, but it says except insofar as he is by or under the constitution required to exercise his function or any of them in his discretion. Here he has to be, he's bound to obey or bound to go by the advice of council of ministers who are the democratically elected people, to the extent of his first capacity, in the dual capacity and the first capacity. What's the first capacity? He is the head of the state. But in ensuring constitutional machinery in the state, as a representative of the center, he need not go. It is not compulsory, or rather, governor is vested with a discretionary power to be exercised to ensure in the representative capacity of the center, so as to ensure constitutional machinery in the state. Moving further with this, it says that when to exercise his discretion, the decision of the governor shall be final, and it's also declares, the constitution also declares that governor shall not be whether he has properly inquired his discretion or not cannot be called in question in any court. That's what it says. So that's all about Article 163, and this is what we are expanding on. So discretion of the governor is something which makes him unique, and which will really underscore his position under the constitution. So there is an article which all of us are aware, I feel, Article 200, which speaks about giving assent to the bills passed by the legislative assembly of the state concerned. Here, ordinarily, giving assent is similar to that of the president's giving assent, and it says that he can give assent or he can return it, and if it is reconsidered by the state legislative assembly, and if it is again given, again sent back, then he does not have any discretion to do this. All these are mentioned, but importantly, there is a provision which which gives a discretion to the governor to reserve certain bills for consideration by the president. And president, if we go to Article 111 of the Constitution, we can say that president also has similar position as to position as to giving discretion. But here, when it comes to state bills and giving assent to state bills, it is not obligatory. It is not obligatory on the part of the governor, no, sorry, and on the part of the president to give assent. Here, president has the flexibility to exercise an absolute veto, not only a temporary veto. If it doesn't give assent to that, there is no compulsion on the governor, unlike many other many other countries like US. And when it comes to state bills, the president, that means the center, can stop a bill being passed by the state government if the governor has exercised his discretion, and governor is appointed by the center and is a person of the center. Now, when it comes to Article 254, when there is a matter of concurrent list, as we all know, both center and state can exercise power here. But if there is already a law which is passed by the center, then governor may exercise his discretion, saying that as these laws, state laws and now center law, if there is a chance of a conflict, then it can be reserved for the assent of the president. Then going further, under Article 256, if it is a law which relates to certain matters, then the center can give direction to the states, and even in that, governor may play a role. And similarly, center can give direction as to means of communication, and here also, through governor, the center may use some discretion. And importantly, Article 304, if there is a law which affects free trade and commerce in India, because India is considered as a whole, and it is declared that there will be free trade and commerce in India. And if a state makes a law which has certain restrictions or regulations as to trade among states, then it can be reserved for the consideration of the president. Again, and the center will decide it. Article 356, all of us know that when it comes to when it comes to state emergency, if the question as to is there a breakdown of constitutional machinery in the state, is decided by the governor, not in consultation with the council of ministers. And no, of course, president need not always listen to the governor, but governor is in most of the cases is the authority which will decide this, and and even dismiss the state government which is democratically elected, and things like that. And when it comes to Article 331 A, B, C, that is a law which might, of course, in the public interest, which might go against direct, the fundamental rights in the interest of directive principles of state policy. If there is such a law, that again, governor can exercise his power, saying that this is to be considered by the president because it affects the fundamental rights. And of course, as I said, if there is a law which is likely to affect fundamental rights, it can be reserved for the president. And if there is a law which goes against the directive principles of state policy, again, if the governor thinks so, he can reserve it for the president. So here, what we can say is there is substantial interference possible, substantial role played by the governor. So, and constitution says so. So there is a possibility, though, as I said said with the first picture on the screen, he's a person difficult to understand. Who is he? What is his position? What is his term of office? All these are kept little uncertain, but he has got a lot of powers to be exercised. So through him, the center governs. He's a governor. It is through him that center governs the state. Center governs the state. Whether it is positively used or negatively used is to be seen. Now, maybe we have got another 2 to 3 minutes only. Through these positions, it's really it can be used. It could be abused, and there are instances where when there is a new government at the center, the already appointed governors were abusively removed from the positions. All those are there, but with these powers and with these discretion vested with the governor can ensure constitutional governance in a country which like India, which is a union of its components, And now I've got that is to say, if you go to Article 1 of the Constitution, Article 1 of the Constitution has deliberately omitted to say federation, but it said union. What does it mean? It means that it is not a coming together. It is not a federation of its units which has decided to come together. India is a single unit. For administrative convenience only, it is divided into different parts. So there are instances India is one India and different worlds. You have got Assam, you have got Kashmir, you have got Punjab, you have got Tamil Nadu, you have got Andhra Pradesh, you have got different worlds in India. And if there is a full-fledged federation made available to the people in India, it might wither away. So might be this is the thinking which made the constitution makers to not use the word federation and use the word union, and to ensure this. The center can use governor as a conduit pipe to ensure this. Whether they are actually doing this or not is a different question, but this is the possibility. And going further, extending this argument, the integrity of India, integrity of different worlds and different people of India can be ensured, and state can be brought within, and the coherence of India can be ensured through the post of governor. And uniformity of laws, there could be uniformity of laws through this, a law which is different from a law which is passed by the center, or which is not in conformity with the constitution, can be put in line, or channelized through this mechanism of governor. And there could be uniformity in administration too. There could be uniformity of administration in the sense that if there are provisions for even declaring state emergency, if there is no constitutional machinery, there's a provision for giving direction to the states. All this can be exercised through governor. So what I would say is the governor, in a way, the position of governor, or the dual role of the governor and the discretion made available to the governor, unlike president, ensures that constitutional governance is happening in India, which is not a federation, which is a union, which has a tendency perhaps to wither away. And that might be the reason why the constitution makers thought he should be made uncertain, which is he can be available, there can be a grip on him only for the center, and there's a lot of discretion with him, which can be used for the purpose of ensuring that states don't wither away from in the nation called India, and India remains what it is. Of course, we have got examples of things otherwise, abuse of power by the governor and things like that, which I don't think I've got time to discuss now. But perhaps in the post presentation question answer session, I might answer those questions. So that's all from my side, and thank you so much for the invitation once again. Now it's over to Safi Mohan sir, my dear friend and colleague. Thank you so much. That's it from my side.
Different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is I think is a constitutional